All right, Mr. August Fest.
Mic check.
And please introduce yourself for the record before you begin your testimony. Thank you.
Yes, my name is August Fest. I don't think it's a big secret which way I come down on this bill. I'd like to start with written testimony I've already provided, just touching on some of the points and maybe some of the points that were mentioned by the first panel. And maybe I can come back in the afternoon session and comment subsection by subsection. Due to the storm, my computers have been out. I'm running on a 775 socket with Linux Mint and no printer hooked up, so I'm at a little bit of a disadvantage. What I did already send to Senator Ridgell. Oh, let me first start by saying, God bless you. And anybody else that votes for this bill, any other senator that votes for this bill. Fraud for the last 100 years needs to stop. Schedule 1, out and out fraud on the plant. Schedule 1 says no medicinal use. How many states say otherwise? How many doctors say otherwise? So, out and out fraud. Potential for abuse. Anything has a potential for abuse. Me standing here is a potential for abuse. Okay, this is, I'm just going to touch on some things. I'm not going to take a lot of your time and get too far into the weeds with this, no pun intended. As previously, I sent this on February 2nd. Previously mentioned and suggested that any tax and all tax, including excise tax, should be collected entirely at the end point of sale to the consumer, as in the current subsection, no tax shall be levied on cannabis intended for medical use. The way it is currently stated and collected from the cultivator only, would require the cultivator to separately cultivate or separate flowers specifically for medical use. This also complicates the process and products from a processor or manufacturer. To simplify tax exemption, collecting the tax at the end point of sale, a registered patient shows proof of status at the sales register, and whatever products are purchased by the patient would be a medical tax exempt sale. I feel the change would simplify the process and tax exemptions for all concerned. This would also maximize the tax revenue collected on the retail price of products rather than at the lower wholesale cultivation price. Submitted on February 3rd. Sunset clause for medical home cultivation with its much higher plant counts. This was the bill Senator Muna authored and re-amended, and I testified against that sunset clause. Now, your bill says retail outlet. Some would argue that it's the same thing as a dispensary, but either way, if a regular citizen can cultivate, this sunset clause in Senator Muni's bill needs to be amended, taken out. Because with the passage, the Act nullified the sunset clause for medical home cultivation with the much higher plant counts. MPL 34-125 subsection 122.530A should be amended within this new bill 32-35. The words, if there is no operational dispensary for medical cannabis products, that part should be deleted. The higher plant counts and possession per patients should be upheld. I've already mentioned that. The higher acquisition, cultivation, possession for patients should not be affected, but it should be specified in this new bill and to amend Public Law 34-125. Now, with a current patient, the way that the 33-220 is set up, it says 2.5 ounces every 2 weeks. But then again, it's specifying purchase from a dispensary. If you go to the previous law, which is now, I think, 32-237, it doesn't have a definition of allowable amount. It has a definition of, what is it? Anyhow, it's more specific to the possession for a patient. Adequate supply, that's what it was. It was adequate supply. And it said no more than a 3-month supply. Well, if you take the new definition of allowable amount purchased from a dispensary, 2.5 ounces every 2 weeks, you times that, you do the math, you're ending up at a pound for a 3-month supply. So just points of interest that should be amended by medical cannabis bill authors. I submitted this on February 8th. Off-island testing, U.S. Congress reps, the Congressional Research Service, National Council of State Legislature, Professor Mikos, and DEA, and Senator Barnes. The past email string reaches out to all. The description of my interaction with the local DEA office prior research into the matter and reaches to local senators and now the former current Congress reps, staff, the National Council of State Legislatures, Professor Mikos, and the Congressional Research Service Attorney Ye. I had sent him a long email and looking at his work product for Congress in past years. One would read his work product and would suggest that the exemption for the Department of Health would be authorized. Not only, it is already authorized in our current public law that they be allowed to test or conduct tests, but if you read Attorney Ye's work product for the Congress, it states an exemption for offices or officers or persons involved in the enforcement of controlled substance are exempt from DEA registration. And if you follow that into the postal code, it lists the same exemptions. Now, Attorney Ye did do his research, and he finished up. He sent it to former Congresswoman Bordallo, but she dropped the ball, put everything in a box, and threw it away. We don't know. The current Congressman, Senator St. Nicholas, through my contacting and Senator Ridgell contacting him also, they reached out to Attorney Ye. He said, I already gave it to you guys. Now he has to go back and dig up what he sent Congressman Bordallo. So we've got some kind of statement on it from a congressional research attorney. We just don't know what it is because he's got to dig it back up and send it to us. But the way that the wording doesn't limit the Department of Health or Customs or the local police to only testing medical cannabis, it would allow any one of these departments to contract with an off-island stateside testing lab and conduct tests on it for adult use also. I won't go into the long letter or read it for the value of time, but I did send it to all those persons. Let me figure out where I'm at here. I'll just maybe summarize what Attorney Ye's past work product was. So this is on page 15 of one of his documents. Summary. May state, nope, that's the wrong one. But it absolutely just says any officer or office of a local jurisdiction is exempt from DEA registration. So by Department of Health's own mandate to protect the people, it's part of their mandate to protect the citizens. Submitted on February 6th. Micro businesses. Please consider for your bill in the forthcoming commission to make allowances and accommodations for micro businesses as lesser licenses and permits fees as in legislation for the CNMI and many other stateside jurisdictions. Please add this to testimony. February 27th, doctors. For testimony bill 32-35, as in other states, and as here in Guam, finding a doctor that is compassionate and or understanding cannabis as medicine is not at all easy to come by. This is an excellent reasoning for this bill, 32-35. Everybody's having to play hide and seek with a doctor, and the doctors are uninformed what's been on the books from the Supreme Court since 2003. They cannot lose their license, can't be penalized, DEA registration or otherwise, just for merely recommending cannabis to a patient. And in our law, our form from the Department of Health, it's not even a recommendation. It's merely a certification. It's the doctor is only certifying that he has a bona fide relationship with the patient, and in his opinion, the patient has a qualified condition, and he believes in the potential health benefits, not proven health benefits, just potential health benefits. And he also testifying that he believes that it may likely would outweigh the risks to the patients. So what he's only saying is he has a potential likely belief. Now, if you certify, testify, and state that you believe in God, that's not the same thing as you recommending someone to go to church. Two different things. He's only testifying that we have a relationship, he's got a condition, it possibly may help him, and it probably won't hurt this particular patient. His doctor is not stating that he's recommending anything. There's no word recommendation in his statement. That's it for my written testimony I've already submitted to Senator Ridgell. If I can briefly comment on the last panel's testimonies, I will, if I can come back in the afternoon session, and I'll study the bill further, make notes, and make quick comments. I didn't catch the first citizen's name that when I walked in, but he's talking about scientific studies on brain development. If you look at the studies he refers to and anything in the National Center for Biotechnical Information, when you look at these studies, and I've noticed this since I started studying medicine for my own conditions, when you look at the doctors, it's almost like legalese. They use words like may, could, suggest, and possibly. What Zerzan and the other gentlemen, when they were saying about these studies, you got to read between the lines. They're not saying, yes, this is true, this is positive, this is what's going to happen. It may be. It could be. It suggests. The language is very suggestive. Paul Zerzan. Sorry, is this brazen BS, excuse me, the study from Colorado. No causation with the studies with the driving and the fatalities and everything like that. If you consume potent cannabis right now today, 28 days from now, you're going to test positive. And that's the problem with these drug tests and urine testing for employment. They're not testing for active tetrahydrocannabinol. What they're getting is, once your brain absorbs, the synapses absorbs the THC, it leaves a byproduct. So it's like a campfire. You have a campfire. Yes, there's a campfire. That's burning. It's got active constituents to it. 2 days later, you have a pile of ashes there. That's not a campfire. That's not active. So in your blood and your urine, what gets stored in your fat cells is the byproduct of your brain absorbing or using the THC. So you're seeing residual byproducts. You're seeing waste products. So it's not active. So any of these studies that show a correlation, they don't actually show a correlation. They just said, well, they had THC. Again, you consume some potent cannabis, if you can find some. 28 days later, only the byproducts are going to show up in your urine test. Has no effect on your performance whatsoever. He also mentioned something about hemp, and it's not a good thing. Oh, one thing Paul Zerzan said, increase in syphilis because of cannabis use. Really? Come on, how do you even make that correlation? Hemp, I would say, used less pesticide. He was downplaying the hemp industry. You got less chemical pesticides and versus nylon or plastic products. That's all done by chemical process. Hemp is much more organic and friendly to the environment. So we got the brainwash trying to brainwash us. Yeah, this brainwashing thing has been going on for about 100 years now. There are no gateways. There are only choices. Period. This is just the rhetoric of the paranoid prohibitionists. And I hear people say, you know, with smoking marijuana, you're going to become paranoid. I say it's the prohibitionists that are exhibiting paranoia, foaming at the mouth paranoia. Mr. Cotton, he made a good point. It leads away from alcohol and opiates, and it's an alternative. It's an alternative. It's a very safe alternative. I know for myself, I haven't consumed a drop of alcohol since, I didn't keep track of it, but I think it was 2000 or 2001. I did not replace it with cannabis because I was already a cannabis user. So there was no replacement. I just took alcohol out of my consumption diet. I didn't replace it with cannabis because I was already a big fan of cannabis anyhow. I didn't increase my use of cannabis, but it was something that would allow me to stay away from alcohol. It's a safe alternative, you know. If you can spend your money on something that's as pleasant as cannabis, why spend your money on all that other man-made stuff that does make it crazy? That's all my rebuttals so far. I will continue to take notes in the afternoon section. I will study the bill again and make notes on some of the points. I do want to say, I know off the top of my head, this commission or whatever who's going to come up with the rules, don't make the same mistakes we did with medical. Don't put prohibitionists in charge of making the rules. You're just, that's just a recipe for failure. You have to have people that are pro-cannabis, fresh blood, fresh minds, and please, dust away the prohibitionists and the paranoid people, and let's start making sense of our lives. See you in the afternoon session. Thank you.
Thank you, Mr. Fest.